special guest to talk to us today. It's John McKinnon, who is the director of the Injured Workers Community Legal Clinic. And you know what? I'm just going to pass it over to John already. We're well into the morning already. So, John, I'll turn it over to you.
Okay, great. Thanks, Jules. Can everybody hear me okay?
Yeah.
Good. Okay. So yeah, hi everybody. I see lots of old friends are on the call. It's great to see you guys and see that you're still active. So today I'm going to talk a little bit about issues related to turning age 65 and being on compensation and the poverty that we see. And in a minute, I put some of it on some PowerPoint slides, and I'm going to try something fancy in a minute and put them up on the screen, and we'll see if it works. So it'll give you something else to look at. You know, we all have seen what poverty happens to injured workers at age 65. But there's been some research done by some of our academic friends that confirms this. So some of the statistics that we often quote are from a study that Perry Ballantyne and a few other friends, Becky Casey, Fergal Hagan, and Pat Vino, did a few years ago. And they found that looking at people with permanent disabilities, 46% of that group lived in or close to the poverty defined by the low income measure that Statistics Canada uses. 9% of people lived in deep poverty, and we also like to quote some of the research from the Institute for Work and Health that Emil Tompa did. He was able to look at combined data from the WSIB and from income tax data, the Canada Revenue Agency, to look at people's total income. And so he was able to zero in on people who had a permanent injury that had an L rating of between 10 and 20%. So of those people, and 10 to 20% is not a big permanent disability rating, 41% were making less than a quarter of what their uninjured coworkers were making. So that's huge. And we know from the numbers of people on ODSP, well over 3,000 people are on ODSP and are also receiving their tiny loss of earnings benefit. But the thing about these studies is that they're looking at injured workers with permanent disabilities in general, and most of those people are still getting their loss of earnings benefits. And so we all know what happens at age 65, that ends. So it's a particularly serious problem at age 65. So a few things that I wanted to talk about here, and let me just see if I can do this sharing my screen business and see what happens. So you don't want to see that email. You don't want to see that. This is what you want to see. Okay. So can people see that slide now? Does that look good? Okay. So I'm just going to talk about a few things that are related to age 65 and poverty issues, and then have some discussion. And so we're going to talk a little bit about the permanent disability pension system. And we're going to talk about the effect on injured workers of going to the wage loss system, and then the effect of ending mandatory retirement, and then look at what we can do to maybe make the system work better. Orlando, who works with me, who you met already, gave it the sort of nickname Institution Project, because when you see how we got to where we are, really just giving back injured workers what was taken from them would put a lot of injured workers in a much better position. So I want to try and show how that came about. So we had a permanent disability pension system, and that applies to accidents before 1990. And with that, there was security of payment. If there was a permanent physical injury or psychological disability, there was a pension for life, same amount every month for life, was based on a percentage of your pre-injury wages. And that percentage came from a table that people refer to as the meat chart, really. And it was supposed to show the effect of the different types of injury on the earning capacity of the average worker. So not you in particular, but the average worker. So it had figures like, for example, for the loss of a leg or an arm, 50%. If you had a significant back injury, it had a range from 10 to 30%. There were problems with the percentage for many of the injuries, but the concept was that security of payment was best for both compensation and for rehabilitation. So guaranteed monthly payment for life. And because the pensions were sometimes, significantly low because the percentage was low, political pressure led to the development of supplements paid on top of the pension. And so, for example, as a result of political pressure, the government and the board developed something called the older worker supplement. So if you had your injury and say you were over 50 and had been working in heavy labor, and your pension might not be that high, but you're not going to get back into the workforce, they could pay something called the older worker supplement on top of your pension. And that supplement was made to be equal to what you'll get in your old age pension when you hit age 65. So again, the theory was that your benefits aren't going to change at age 65. Things will carry on and make the best of it you can. So the basic concept and underlined the permanent disability pension system was an injured worker's income shouldn't change at age 65. So then came the wage loss system. And that all came from a report back in 1980. There were a few reports by a guy by the name of Paul Weiler. So back in around the late 70s, early 80s, injured workers groups were developing all over the province, and they were very good at showing the injustices in the workers' compensation system. They were getting sort of recognition of the injustice and some political power. And also there was very high inflation, throughout the 70s, and there needed to be cost of living adjustments every year, because in the early days of the pension system, $300 a month was worth $300 a month 1 year and 10 years later, basically. But inflation created problems with that. And so these were the injustices that injured workers were talking about. But the bureaucrats and the politicians, they were starting to worry about the cost. Like if people are getting these payments for life and inflation is like at 10% more per year, all of a sudden the future cost of workers' compensation is looking very big, and who pays for that business? So politicians, businesses, and bureaucrats were starting to worry about the cost of workers' comp. So the Ontario government, and this was back in the Bill Davis days, they hired Harvard law professor Paul Weiler to study the issues and to recommend changes to workers' comp. And so Weiler, he criticized the pension system as a system of average justice, or he called it rough justice too. He said it ignores the special situation of individual injured workers, and it just was no longer tolerable. And that resonated with people because a lot of people who had permanent disability pensions said, well, this is way too low. I've got a 15% pension and a 100% loss of earnings. So that got some in of a lawyer who loses his arm in a car accident on the way to court. So that lawyer gets a lifetime pension of a much higher income than, say, a laborer would get. But the lawyer might not have any loss of wages, and yet the laborer, especially if she's in a big city with a high unemployment rate, the laborer may never get back to work after losing an arm. So Weiler said we have to deal with this. Average justice is not acceptable. And he claimed with the wage loss system that he was bringing in full compensation to people who were not fairly compensated in the pension system. However, we know today, like people like the laborer who loses an arm and is living in a big city with a high unemployment rate, those people under the wage loss system are the ones who get deemed. They're not the ones who get full compensation. But anyways, Weiler said that he was designing a system, and he said that it was going to fully and adequately replace the actual income losses. And I put a quote up there from the Weiler report. He said, the board should compensate such a claimant for the actual wages lost as a result of his inability to work because of his physical impairment. So that's a good theory, right? Like if you're on a pension and it's really too low and you're not doing very good and someone says, I've got a better system, it is appealing. But that's an actual wage loss system. And the other thing that Weiler did, and he began to compromise even in his recommendations before we actually changed the system, is that he didn't set it actually at 100% of lost wages. He set it at 90% of net wages, net because workers' comp benefits aren't taxable, and 90% to give people a little nudge back to work in case that's necessary, as sort of an acknowledgement to that bias in society that says, injured workers don't want to work. In the wage loss system that Weiler was proposing and selling to the government, there would be almost no deeming. In his system, he said the board will deem the worker to have income from the job if it's suitable, it's available, and the worker refuses to take the job. And he said something like that's going to require like proof, evidence that either the employer, compensation board, or some other agency made a specific job off to a specific injured worker, and the injured worker to Wayne Gates' proposal in Bill 119. And I missed Wayne's session, but I know he was on talking to you folks. And so what he is trying to get back to is something that was in the theory of the system from the very beginning, that deeming would only apply where somebody offers you a specific job that's been checked out as suitable, and you say, no, I won't do it. So that's still deeming, but that never happens. So it would be a huge improvement if Wayne's bill could get through. And the other thing about Weiler's system that made it look good was that there would be no loss of retirement income. And so what he said is when we go to a wage loss system, and at this time, you got to remember back in the 80s, forced retirement at age 65 was not only permitted, it was the general rule in most workplaces. And so Weiler said, well, if we're paying you a benefit that's just related to your lost wages, then that should end at age 65 too. It happens to most people. But he had special protections built into his proposal that never actually saw the light of day when the government came around to implementing it. In the theory of the wage loss system, he said that the compensation board will somehow maintain whatever benefits package you had in your workplace. So health care and whatever retirement you'd have, that would carry on. He said also that the compensation system ought to contribute your contributions to unemployment insurance and to CPP, and they don't, and that's a huge problem. But in his theoretical system that he was selling to the government, that's what he proposed. And you'd have to make arrangements, obviously, with the federal government, and that's where it sort of becomes impossible. And he said where it's not possible, then the board should compensate the injured worker for the loss by calculating the appropriate amount. And so he's not talking about some kind of rough justice. He's saying do an actuarial calculation to pay into a registered retirement savings plan enough money to provide the injured worker an annuity at age 65. And an annuity is also a special word in the sort of accounting and actuarial business, because that's a payment for life. Means a fixed amount of money that you're going to get every year for the rest of your life. So these were all part of the theory of the wage loss system, which the government of the day fell for. And so in practice, didn't turn out to be quite the same. So we had in the first system, which was introduced by the Liberal government back in effective for accidents, basically from 1990 onwards. There was the wage loss benefit. The first one was called the FEL, which stood for future economic loss. It's really the same idea as the LOE, or loss of earnings benefit. So that was set at 90% of net, and that's something that Weiler proposed, which introduces a little bit of poverty into the system, and a little pushback to work that Weiler proposed. And then there was an additional 10%, not taken out of your FEL benefit, but an amount equal to 10% on top of that was put into a loss of retirement income fund. And the theory behind that 10% figure is that when you look at the Canada Pension Plan, which people contribute if they're working, the total amount that is put in by you and your employer together is around 10% of your earnings. So the 10% loss of retirement income fund contribution was intended to kind of roughly replace what you're losing from the Canada Pension Plan. So that was part of the first wage loss system, but also there was deeming, which Weiler said there wouldn't be, but your benefits, injured workers predicted that it would be back when Weiler's proposals came out. He mentioned that it was being already used in places like Saskatchewan and in some of the United States, and we contacted injured workers there, and we found that in fact it's not as nice and perfect as the theory is, and that benefits get reduced basically by what the board says you're able to earn. And you're able to earn whatever the wages are paid for jobs the board thinks is suitable and are out there in the general labor market. So deeming, of course, as everybody knows, it reduces your wage loss benefit, so that creates poverty now. But then it also hugely reduces what's paid into your loss of retirement income fund, because you're no longer getting 10% of what you're losing in wages. You're getting 10% of this small imaginary future economic loss award, and so that increases the poverty later on because deeming reduces your ongoing benefits. So that was the first version of the wage loss system, which was in place from 1990 to 1997. And then came the Mike Harris government, and we got the conservative version of the wage loss system, and that was in Bill 99. And like a lot of changes, they start with a report. And so the Mike Harris government got MPP Cam Jackson to travel around the province a bit, hear about workers' comp, and come up with some recommendations. And you have to bear in mind that part of the Harris election platform was on the basis that employers are paying too much for workers' comp, and the system is too generous. And so Cam Jackson traveled around. He heard from some of us, and he wrote a report. And I just put in that quote there: benefit enhancements over the past decade have resulted in an unfunded liability whose size threatens the future viability of the workers' compensation system. And there you have it. The benefit enhancements are too generous to injured workers, and the system may fall apart because of this unfunded liability. And that's been brought out year after year after year to justify cuts to the compensation system. So in his report, he said, you know what you should do? You should reduce the benefit levels from 90% to 85%. Not because that's fair, but because the system's in crisis and everybody's got to tighten their belts, and that includes injured workers. And he also said you should cut the contribution for the lost retirement income fund in half. And he also said you should only pay partial cost of living adjustments. And all of that just because the system's in trouble and people have to tighten their belts, and that includes injured workers. And so he did some calculations about that, and the actuary said, if you do that, if you just change those numbers in the law, then of course you have to recalculate the future cost of workers' compensation, and the unfunded liability drops by about $14 billion just at the stroke of a pen. Before you start paying out a cent or a cent less to injured workers, just change those numbers and the unfunded liability drops $14 billion. And at that time, it was only a little over $18 billion. So just by cutting injured workers like that, almost eliminated the unfunded liability. And of course, the government did what Jackson recommended. And that was in Bill 99. So they changed the name of the benefit from the future economic loss to the lost earnings benefit, but it's basically the same idea. And they cut it down to 85% of net, down from the 90%. So there you go, increasing the level of poverty even for people who are getting full compensation. And then they cut, again, the lost retirement income fund contribution from 10% down to 5%. So that reduces what you're going to get at age 65, really to less than half of what we would have got under the old system, which was not great, but it's less than half because now the benefits for injuries are only 85% of net, and then only 5% compared to 10% is paid into the loss of retirement income fund. So that was a huge cut for injured workers, and of course, difficult to appreciate if you're younger and you're not near age 65 and you're not thinking about how all of this plays out. So, and of course, also in Bill 99, there was still deeming. Actually, they made deeming even a little bit worse because originally the board could determine your income not by your actual wages, by what the board thinks you can do in a job that it thinks is suitable and available out there in the labor market. So that availability issue was an opening to challenge the board about deeming. So the conservatives just took the word available out. So there doesn't even have to be a job available for you. If there is, in theory, somewhere a suitable job, then so that further reduces the wage loss benefits, increases poverty now, and it further reduces what you're going to get at age 65. It magnifies the poverty. So things got much worse starting in injuries from 1998 onward. Another thing to figure into this is the effect of the end of mandatory retirement. Because when the wage loss system was brought in, you remember, people were forced to stop working at age 65. It was permitted under the Human Rights Code, and it was the common standard in most workplaces, out the door at 65. So Weiler said, well, because of that, that's why your wage loss benefits end at age 65. Now, Weiler had proposed, remember, some other benefits that would sort of be equal to what you would have got if you kept on working. So that was a nice theory, but that never made it into the government's actual law about the wage loss system. But since then, there was a lot of public pressure and political pressure as a lot of the baby boomers got closer to age 65 and said, it's not really tolerable to have forced retirement. And so the government proposed to change the Human Rights Code that would protect people after age 65 and it would put an end to mandatory retirement. So seeing that happening, and of course there were public hearings and everything. So injured workers groups, and I know some of you guys were involved in this. This was back in 2006, I guess. Yeah, injured workers groups were saying, okay, well, this should be a return then to the pre-1990 permanent disability pension system. But some organizations, and that includes the WSIB, it lobbied for an exemption to protect the age-based limits, 65 basically, under the Workplace Safety and Insurance Act. So there are public hearings around this. And the amazing thing about that is that even the Ontario Human Rights Commission made a submission to the public hearings against the exemption of the WSIB. It said those age 65 limits in the workers' compensation law, they used the phrase offensive to human dignity. And the Human Rights Commission, the government, if you are going to go ahead and offend human dignity by continuing those limits, if you need time to change the system, make this a time-limited exemption. Give yourself a few years, fix the workers' comp system, and get rid of those age limits. But unfortunately, the government just protected the WSIB from the Human Rights Code. And the reason they gave is that the workers' compensation is a complex program. And they said, and this is what their reasoning was, age-based limits were needed to preserve the integrity of this insurance plan. But, when you think about it, you could say that getting rid of the age 65 termination of loss of earnings benefits was necessary to the integrity of the system, because your benefits only stopped at age 65 because you could be forced to retire at age 65. Now we got a system where nobody's forced to retire, and nobody's benefits should be automatically cut off at age 65. So it was a bogus reason, really, that just kind of preserved the system and kept the costs under control. So in Ontario, the government said it's too complicated to deal with our age limits. We ought to be protected from the Human Rights Code. But it was easy for British Columbia, and that's the interesting thing. Because in BC, their law has similar age-based limitations to ours. And in BC, the workers' compensation system, the WorkSafe BC, gives injured workers an opportunity to present their individual circumstances to the compensation board. So if the WorkSafe BC is satisfied that you planned to work past age 65, then the law allows the board to keep paying your loss of earnings benefits up to the date that you would have retired. So it's really not too complicated. It's really pretty easy. They do it in BC. Not necessarily perfect, because you gotta prove your case, otherwise you will be cut off at age 65. But at least there's a system that gives you a chance to speak to that and to give your plans to keep on working. So those are the sort of deteriorations of the system, from the permanent disability pension system down to the wage loss system, and then to the cutback wage loss system under Bill 99. Of course, it's unfair in so many different ways. And topics for another day would be looking at some of the legal challenges that are out there. Under the Charter of Rights, for example, age discrimination, I have no doubt that that argument is going to win someday. But it's a long process. I tried with an injured worker, and another advocate tried with another injured worker, and unfortunately both injured workers passed away before the case got into the courts, and the case dies if the worker passes away. And of course, these are all injured workers that are going to be well past age 65, and they've got to go through the whole compensation appeal process up to the appeals tribunal before they can even get into court. And if you're older and you're disabled, you've got a cascading bunch of disabilities, and unfortunately injured workers have a shorter lifespan. And so the main reason this has been struck down by the Charter of Rights is unfortunately because people who try don't live long enough to get through the court system. So there's other arguments that we're looking into we can talk about, and the Onywig Research Advocacy Committee has done a lot of work about this as a breach of international human rights law, because Canada has signed something called the Convention on the Rights of Persons with Disabilities, and by doing that, Canada agrees to provide an adequate standard of living to people with disabilities, and it agrees to provide equal access to retirement benefits, and clearly it does not. But what I want to talk about today, and then open this up for discussion, is looking at the best case scenario within the current system. Because when you look back at what's happened over the years, injured workers have lost a whole lot of potential benefit at age 65, just in the name of having to make sacrifices to preserve the financial stability of the Workers' Compensation Board. And now, thanks to the great wizard Tom Teehan, the compensation system is over 100% funded. So now it's time for restitution to injured workers, give injured workers back what was taken away in the name of saving the compensation board's finances. So what would that look like if we're just talking about giving back to injured workers what's been taken from them over the past 30 years? Well, of course, at the top of the list, we'd want to get rid of deeming, and it comes up in every conversation. We'd want to get but we'd want to see something like Wayne Gates' bill, compensation for the actual wages lost, and that would lead to a more precise compensation. If you are actually getting benefits based on what you're actually losing, there'd be less poverty today while you're on benefits, but of course a lot more going into your lost retirement income fund, and so a better chance of living past age 65 with some kind of decent level of a standard of living. So getting rid of deeming is always top of the list, but also restore the 10% contribution to the loss of retirement income fund. Cutting it from 10% down to 5% was just purely a belt-tightening measure imposed by the Conservatives because of the system was allegedly in financial crisis, and it wasn't then, and it's certainly not now. So give it back. That will more than double what you're going to get at age 65 just with the loss of retirement income fund. And of course, even better than the fund would be to contribute that money, that 10%, to the Canada Pension Plan, so your CPP contributions carried on. That's a difficult, complicated thing because it involves the federal government and all the provinces and everything. So it can happen in the near future. So that's why just set the contribution to the lost retirement income fund back at 10% would be a big step in the right direction. And also, carry on your loss of earnings benefits to a realistic retirement age. It's not too complicated. It's easy. BC does it, and it gives people a chance to state their case and to get their loss of retirement income benefits to carry on to when they actually would have stopped working. So that's sort of my thoughts, or our thoughts so far here at the legal clinic on what would be a sort of a quick fix, a best case scenario working within the current system. Get rid of deeming, and whether or not that happens, put the contribution to the lost retirement income fund back at 10%, and give workers a chance to talk about when they would actually have stopped working and carry on their loss of earnings benefits until that age. So I talked a whole lot, and I didn't stop and invite questions, but that's basically what I wanted to